What's up, everybody? Welcome back to Rascal Reacts, where you ask for my 2 cents and I give you a nickel. Man, people have asked for my 2 cents on this a lot since yesterday. I'm in California. I got my kids, and so my time is kind of limited. But I wanted to get into this. So, Chemo's Flicks, in case you're not up to speed, real quick, Chemo's Flicks posted a video yesterday, last night, I think, and showed a bunch of paperwork, right, concerning dubs. And so this is that paperwork, best as I can tell. I used the case number that I saw because I'm not gonna pause a video and read it and go around the emojis and everything. But so I took the case number, I looked it up, I found it, and it's legit, right? It's not AI or anything else. Not that I think anybody's claiming it, but just to be clear, I got this off the Pacer website. So this wasn't emailed to me. I did not get this off of a video. I got it off of the court website. And it's concerning a lawsuit. Okay. This is the initial lawsuit filed in 2007 by Dubs while he was still in Pelican Bay. His name is John Daniel Villa Jr. You see the plaintiffs in the case, 4 doctors and 3 nurses. And I'm not going to read through all of this, right? It's like 20 pages, handwritten. It's kind of giving me a sense of his writing style, but I'm not going to go through all of it. It's safe to say, honestly, from what it looks like to me, it's a money grab. He was suing them for not giving him a vitamin, niacin for high cholesterol or high blood pressure. I think high cholesterol. And he was claiming, hey, when I was in New Folsom, I was on this vitamin. And then now in Pelican Bay, you're not giving it to me. They had prescribed him other medications. He said that he had allergic reactions to those medications that made life unbearable. There was hives and swelling and stomach aches and all sorts of stuff. Like I said, to me, it looks like it was a hustle, in essence. Hey, let me sue the California Department of Corrections. Let me sue these doctors and see if I can get a couple bucks out of them. There are a lot of folks in the SUE program, a lot of validated people in particular, who take this route if it's, if circumstances allow for it, because it's hard to make money in the SUE. You can't hustle the same ways that you can out on the yard. And so this is another form of a hustle. And I believe that is the case. I mean, who knows? Maybe Dubs really has, high cholesterol or whatever. I don't fucking know. But it's a vitamin. He was fighting. He was fighting to get a vitamin. And instead of just giving him a damn vitamin, like, they made life difficult. So that is what this is about. Right. And this motion, this set of the paperwork, is a petition for writ of habeas corpus ad testificandum. That's a cold word. Declarations of Philip A. Babich and John Villa. And there's copies of some of his prison chronos in here, so we'll get into those. We're going to get into his declaration right now. The declaration of Babich is his attorney. Okay, so what is a petition for writ of habeas corpus ad testificandum? It is essentially the court, right? This is a federal civil rights lawsuit. And this is the federal court telling the California Department of Corrections, you need to produce this dude for him to participate in and testify and listen to the testimony in his civil rights lawsuit. He is the plaintiff, right? He is the one who says, hey, I have a problem. The defendants are the one who he's saying are responsible for his problem, just to put it very basic, right? And so this is not about a criminal case. This is not something involving the MA or any other criminal enterprises or groups or any kind of, criminal violation. It's a civil rights thing. And think about it, right? You're sitting in prison. You can't just tell the prison, hey, man, I got court, in Oakland on Tuesday. Yeah, right. They're just not going to put you in a bus and send you over there. So the ad testificandum part is the court. You're telling the court, I need you to tell CDCR to make sure that I'm where I'm supposed to be when I'm supposed to be there to participate in this lawsuit. Now, it takes a lot to get to this level. I have filed a writ of habeas corpus against the California Department of Corrections myself concerning my validation. I never actually got to have a hearing. I never got to go out to court or anything like that. But the order to show cause, you have to go through the whole 602 process, right? The inmate appeal. And you have to take that up to the director's level and get a judgment and then turn around and file your habeas corpus on your own. They don't give you an attorney for that. You file your habeas corpus, and if the judge believes that there might be some merit to it, he will issue what's called an order to show cause, an OSC. When that happens, that's what triggers you being allowed to have representation at the government expense. Okay. So then the court appoints you an attorney. In my case, I did get an order to show cause in fighting my validation. I was appointed an attorney while I was in Pelican Bay. He sent me a Christmas card and told me, you know more about this stuff than I do. Let me know if you need help with research. And that was that. Anyways, this is not about my case or my stuff. It's about Dubs, but just giving you guys an idea of what's going on here, right? I was going after CDCR because I felt like the process of validating me violated my constitutional rights. I never succeeded on that enough to get out of the shoe. I wound up paroling. Dubs is fighting his medical treatment. Okay. So, and the attorney is giving a declaration because there's some issues, right? Basically what happens is Dubs winds up debriefing and he gets transferred to other prisons. And, in the transport of him going back and forth to attend court in Oakland, I believe, he's being put in contact with actives. So his attorneys are like, hey, you got to stop setting this dude up for failure and just get him where he's supposed to go and kind of do your job. That's the whole thing in a nutshell. But let's go through, piece by piece and see what is said. John Daniel Villa Jr., inmate number J38001, is a necessary and material party in the proceedings in this case. Mr. Villa is confined in Ironwood State Prison. So this was filed in 2012. And it's document 228, right? And obviously they start at 1. This was an ongoing case for years. But so anyways, he is confined in Ironwood in Blythe, California. He is the plaintiff in this matter. Because Mr. Villa is a former member of the Mexican Mafia, his life is in danger each time he is exposed to the general population of the California prison system. The Mexican Mafia assassinate former gang members, such as Mr. Villa, at any opportunity. For that reason, plaintiff respectfully requests that the court issue a writ for his transfer to San Quentin State Prison for purposes of his February 21st, 2012 trial, with the condition that he is transported without members of the general prison population in the same vehicle. Additionally, plaintiff requests that the court order that his transfer may not occur until after February 17th, 2012, because Mr. Villa has a parole board hearing that day at Ironwood. So what it seems like, right? And like I said, we're going to keep reading, but so he's got to go out to court. He has a lawsuit against CDCR. CDCR does not like being sued, right? And in particular in this era, the pre-Asker and all that stuff. He's got a parole date coming up. Okay, so at this point, he's already dropped out, right? And debriefed. He is not active, to say the least, at this point. I think it seems like he was, based on a timeline, I'm sure he was when he started this process, but by now he's not. CDCR keeps putting him in areas around actives, if you will. He has a parole date coming up. If he gets into a fight, based on my knowledge of the system and lifers and that sort of thing when I was in there, if he gets into even a mutual combat with somebody, his chance of getting a release date is gone. When he goes to board, there's game over. Like, hey, fool, you got into a fight, right? Even if it's not serious, even if there's no weapons, anything else. Even if he's if he's a victim, still, you're in a confrontation. We're not going to release you. Like, you're in prison for murder, you're a lifer, and now you have a recent 115. You have, which is a write-up, right? A institutional write-up, a rules violation report. You have a recent 115. You're not getting a date, no matter what else you may have done. So in this case, it would not surprise me, and it would kind of make sense to me that CDCR, they're putting him in positions to get caught up. And then let's say he is in a situation that now they have leverage. Now they turn around and they say, hey, we'll forget about that 115 if you forget about that lawsuit. You know what I mean? And we'll see how your board goes. So it's a leverage play. That would make sense, right? That would not be unusual for how CDCR gets down. So anyways, this is a civil rights claim brought by a former prisoner of Pelican Bay State Prison for damages caused by the deliberately indifferent care provided by 3 healthcare providers. For more than a year, each of the defendants, knowing of plaintiff's need for treatment for a serious medical condition, deliberately disregarded this by either refusing to treat it or giving him a therapy they knew caused him excruciating pain. In doing so, they violated his civil rights under 42 U.S.C. 1983. Mr. Villa's criminal history is known to the court. During his incarceration, Mr. Villa was an active member of a Mexican mafia. However, while Mr. Villa was at Pelican Bay, he decided to leave his gang and began a series of debriefings and programs. On August 23, 2007, a committee at Pelican Bay found that Mr. Villa had been validated as an affiliate of the Mexican mafia. So notice in here, and probably some people are going to pick up on, it says he's a member. It says he's a member. First of all, you can be validated as a member without being a member, right? It is not common, don't get me wrong, but it has happened. To the best of my knowledge, Duz was validated as an associate of the Mexican mafia, which here you read Mr. V had been validated as an affiliate of the Mexican mafia. I have never talked to anybody or seen anything or heard anything to suggest that he was actually a MA member. Was he an associate? Yeah, absolutely. I think that's common sense, right? This is coming from his attorney, right? So these are civil rights attorneys. These aren't criminal attorneys. They don't investigate the MA or prison gangs or anything else. And that means a big deal in the prison community, right? Being a member versus being an associate are two very different things when you're a convict, right? And it seems to matter on YouTube also with people, even though a lot of folks haven't done time and have never really programmed like that if they did do time. But I get that, right? It is very much a difference between being a member and an associate. That being said, to these guys, to these attorneys, it's semantics. It really doesn't matter, right? What matters is the Mexican mafia part. Associate, affiliate, member, that's all the same, right? To them. So that's why, because I don't personally believe that Dubs was ever actually a made member. Anyways, he had completed the first phase of the debriefing process. Contrary to regulations, he was endorsed for a, quote, an intensive curriculum designed to include education classes, personal growth, conflict resolution techniques, and physical education. I've never seen that before. So you got to do Machina when you're in the debriefing program? That's crazy. Anyways, the ultimate goal of this program is to reintegrate inmates that drop out of prison gangs into a general population facility with sensitive needs noted. Declaration of Philip H. Babbage. Right, so that's him. That's the attorney. Obviously, you're not going back to the GP if you debrief, right? But GP with the SNY chrono, you're going to the SNY. So again, the particular language attorneys don't always get right, because that sentence doesn't really make any sense. But you understand where they're going, right? In 2008, Mr. Villa successfully completed the second phase of the program. Committee notes that the safety and security of Mr. Villa and the institution would benefit from his being considered for sensitive needs placement. In 2009, a prison committee evaluated Mr. Villa's request for a prison transfer to be closer to his family. This was granted. This was based on his willingness to debrief, his willingness to walk away from the prison gang mentality and politics, and his positive programming while housed in the THU. The THU is a transitional housing unit, and it'll explain in the footnote what that is. Upon the completion of his debriefing, Mr. Villa qualified for special needs protection. Upon completion of the debriefing process, the inmate shall be housed in a facility commensurate with the inmate's safety needs. In the absence of safety needs, the inmate shall be housed in a facility consistent with his or her classification score. The committee continued, the committee also notes that Mr. Villa has 2 confidential enemies housed at the transfer prison. For 3 years, Mr. Villa has been at risk for retaliation by Mexican gang members for his decision. The Mexican Mafia is the most violent gang faction in California, credited with at least 300 murders per year outside prison on orders that were issued by the Mafia from inside prison. I don't know where they get that number from. Declaration of John D. Villa in support of petition for writ of habeas corpus ad testificandum via declaration. Or maybe that's where they get it from. We'll see. I haven't got to the via declaration part. Because Mr. Villa is a validated former gang member, the California Department of Corrections and Rehabilitation, CDCR, has classified him as a sensitive needs yard inmate, SNY. This classification requires that CDCR keep Mr. Villa separated from the general prison population at all times, including during his transportation. If the CDCR does not keep Mr. Villa away from the general prison population, he will be subject to deadly retaliation from the Mexican Mafia. Let's go back up here and read the transitional housing, right? The Transitional Housing Unit, THU, shall provide a program of observation to evaluate that an inmate has successfully disassociated from prison gang activity and is capable of programming in a general population GP setting. Inmates must have completed the debriefing process from a validated prison gang, as described in Section 3378.1, in order to be placed into the THU. Placement into the THU can be from either a security housing unit or from GP. THU inmates shall be housed separately from other GP inmates due to potential safety concerns. Obviously, I've never been to a THU, but my understanding of it, I think it was at the end of D corridor, right in Pelican Bay, or at least that was one of them. You had, C corridor and D corridor. At the end of D corridor is what I had heard was where the THU was. And again, I could be wrong, and in essence, as you're debriefing, you're housed there, and like they'll sell you up. From what I've heard, they'll sell you up with people who are debriefing from gangs that would otherwise be considered rivals. Remember, all this is before into hostilities, right? So, and it's kind of to monitor you to make sure that you're not a sleeper. They're concerned that people will fake the debriefing process in order to get access to other people who have debriefed and harm them. And so before they go through that, right? Because debriefing is different than locking it up, right? In my time in prison, especially towards the latter part of it, it seemed that just about anybody could raise their hand and say, I don't want to be on this yard anymore. And they would go to a SNY. But that doesn't mean that you debrief, right? The debriefing part is consistent with you being in the mix, right? You've been in the mix. You have worked hand in hand with MAID members, and therefore it's expected that your threat level is higher than some knock who ran up a debt and doesn't want to get slapped in the mouth, right? So they try to be careful, I guess, that you're not faking it. That's my understanding. So let's catch up. However, during Mr. Villa's transportation from Ironwood to San Quentin State Prison for his last trial date in October 2011, the CDCR did not follow protocols for transfer of an SNY inmate, and prison officials placed Mr. Villa on a CDCR bus with the general population. Via declaration. So when they say via declaration, I think this is stuff that he's probably going to talk about in his declaration, which I will read in just a second. This placed Mr. Villa in grave danger. So it's not Dubs writing this, right? This is Dubs' attorney writing this. And then these declarations are the support for this argument that the attorney is making right here. This placed Mr. Villa in grave danger, even though there is a fence on the bus that separates validated gang dropouts who are SNY inmates from the general population. This is not enough to protect Mr. Villa because the general population can see him when the guards call out his CDC number, name, and SNY classification. That notifies all Mexican Mafia associates of his presence. So what I've seen on buses, right, back in kind of this era, I paroled shortly before this was written up, but when you get on the bus, normally you're shackled to the person sitting next to you, right? So there's two seaters, two people on in a bench right here, and then on the other side of the aisle, there's two people on a bench, and you're shackled to the person next to you. But at the front of the bus, just behind the driver, I think there's two benches, so potentially room for four, and there's a cage built around it, right? Or I've also seen where it's like a holding cage. So it's just an isolated cage with a little stool in there, and you sit on the stool, and that's where you're at. But it sounds like this one is those first couple seats, then there's a cage around them. Being in that cage doesn't necessarily mean that you're SNY. Obviously, in this case, it did. But if you're validated and the rest of the population, back then, if you're validated as a member or an associate and the rest of the folks on the bus are mainline, they're not ADSEG, then you might be put inside the cage, right? So it's just to distinguish those couple people from the rest of the people on the bus. In this case, those couple people clearly were SNY folks or dropouts, and everybody else wasn't. And yeah, when they come on and they're calling your name and doing all that stuff, they ain't holding no secrets, right? Guards at San Quentin compounded the threat to Mr. Villa when they took him off the bus upon his arrival at the prison. One of the guards asked another of the inmates who was on the bus with Mr. Villa if he was an active gang member. The inmate said he was. I find it hard to believe. He might have said, "Are you active?" But active gang member specifically? I don't know. The guard then instructed Mr. Villa to follow him. The guards brought over 3 other inmates who were also active gang members to join Mr. Villa. The guards took off the inmates' handcuffs and shackles. Then they told them to strip. At that point, the guard asked Mr. Villa if he is an SNY inmate in front of the 3 active gang members. Mr. Villa was required to answer affirmatively. That placed him in grave danger. Mr. Villa believes the only reason the other inmates did not attack and possibly kill him was because they were white, and he is Latino. So you're in the holding tank, you're in R&R, they put you in a cage, they put you in there with other people off the same bus that you were just on, right? And so then you all strip out together, you're not shackled anymore. It's really is kind of go time at that point, And it sounds like for whatever reason, these dudes didn't, chose not to get off. But that's it. Again, the writing active gang member, they're probably just GP dudes. I don't think they were actually active prison gang members. Danger to Mr. Villa did not end there. The suspense. When he arrived at Chino State Prison during his transition back to Ironwood, the guards placed him and the only other SNY inmate who was riding on the bus in a holding cell. Correction officer came to do a housing interview, which is where the officer asked the inmate if he is SNY and who he can share a cell with. Mr. Villa told the officer that he was out to court for a lawsuit. According to Mr. Villa, the officer said good luck and then walked away. About an hour later, officials at Chino sent Mr. Villa to a unit to be housed with active Mexican Mafia associates. Mr. Villa told the officers that he was an SNY inmate, and he asked the officer whether he was supposed to be there. The officer told him that he was not. Clearly. Mr. Villa believes that if he had not asked that officer whether he was supposed to be in that unit, he would have been killed in the cell that night by the Mexican Mafia. The officer instead placed Mr. Villa in ADSEG because he said there were no more SNY bunks. Mr. Villa spent 3 days in ADSEG. Mr. Villa later learned from other SNY inmates who were on the bus back to Ironwood that there were plenty of other bunks available for more SNY inmates at Chino. It is fortunate that the Mexican Mafia did not reach Mr. Villa. He does not wish to take his chances again. Legal argument. So, and I'll give an opinion on that in a second, but The district court has authority to issue a writ of habeas corpus ad testificandum, the writ, if the court determines that it is necessary to bring the inmate into court to testify or for trial. In determining whether it should be issued, the court considers whether the prisoner's presence will substantially further the resolution of the case, the security risk presented by the prisoner's presence, the expense of the prisoner's transportation and safekeeping, and whether the suit can be stayed until the prisoner is released without prejudice to the case asserted, to the cause asserted. They also have discretion to attach conditions. So here is just the legal argument, right? Hey, Villa has to be in court for this case because it is his case. He is the one suing the Department of Corrections. There are not other witnesses to what he experienced in Pelican Bay in not getting these vitamins other than him, right? And they've been transporting him around and the cost hasn't been an issue. So let's not start with that now. And then waiting until he's out doesn't make any sense because he's a lifer. And although he has a parole date coming up, no idea if he's going to get granted that or when it's going to be or whatever. So no, we can't just wait. So I don't think you guys are particularly interested in the legal arguments. And so that's why I'm kind of scooting through some of this to make the video a little bit shorter, right? So I'm sure that there are people that are like, oh man, what's up with Dubs? Like, why didn't he just get off on the actives, right? And you're not supposed to, behave that way, right? Look, if you're active, no, you're not supposed to, right? If you're active and they put an S&Y dude in a holding tank with you, you better get your money, right? That's active behavior. I was put on a New Flowers yard where I wasn't going to stay in pro. It was GP, but it wasn't any good for my people at the time, so I wasn't going to stay there. I'm not going to tell the COs I'm not going to stay there. I'm going to get off because that's active behavior, even though we didn't use that language back then. But still, you guys get the point. Clear as fucking day, Dubs was not active. So expecting him to behave like an active when he's a dropout seems to not really make much sense. Now, maybe if he was an SNY gang member, right? Because those dudes, all we want to do is get our hands on an active. We want to get our hands on an active. And so if that was the case, then yeah, I would expect that he would take the opportunity to assault actives and just get his money, right? But again, that's for folks that are bitter against actives or view them as the enemy or the opposition or whatever. And my watching of Dubs' content, and I watch most of his content that has to do with prison. Some of the other stuff I can give a shit less about, but the prison stuff I do. He doesn't talk bad about people that are active in the mix. He doesn't disrespect those groups. So I wouldn't expect for him. Now, if he was on here like, oh yeah, fuck the actives and this and that, and then reading this, I think would be like, oh, for you had a chance to live up to that and you didn't. But he doesn't really act that way, right? So it appears to me he was trying to go home. And again, he's playing into CDCR's hands if he gets off or if he does anything, because then it's choose the lawsuit or the 115, assuming that they give him that opportunity. And then that messes up his chance of going home. Look, I will say, and then we'll move on to the next document, right? Or see if there's any more on this. Yeah, we'll move on to the next document. I am not surprised by the information that Dubs debriefed. Okay. I have never said that he didn't. I have never said that I thought he didn't drop out. Common sense from somebody that was doing time in that era. I didn't do as much time, but somebody that was doing time in that era. But this dude's a lifer with multiple shoe terms for violence and is then validated. There ain't no fucking way in hell that somebody that's validated and a lifer just paroles back then. That's not how it works, right? It's clear that there's some years there that he don't really talk about at the end of his time. That's his choice, right? But He hasn't lied and said that I paroled off of active yard or that I paroled from the SHU program or anything else. He just chooses not to talk about it. So maybe I'm in the minority here, but I'm not surprised by any of this. I'm not surprised to hear that he dropped out or that he debriefed or that he was on an SNY yard. Again, I think it's common sense for anybody that's done time in California, right? But I don't know. So maybe that's why, to me, this is not such a big deal, but it is something worthy of conversation because, he's on YouTube. So Philip Babbage, his attorney, says, I'm an attorney at law and associate of law firm of Reed and Smith, attorneys for John D. Villa Jr. in this action. I am admitted to practice in this court as well as all courts for the state of California. For the reasons stated, I have personal knowledge of the following and can competently testify to the contents of this declaration if called as a witness. I make this declaration in support of plaintiff's petition for writ of habeas corpus ad testificandum. Attached as exhibits 1 through 3 are true and correct copies of the summaries of meetings concerning Mr. Villa's debriefing process, as well as the recognition by the Department of Corrections and Rehabilitation as a sensitive needs prisoner. I met and conferred with counsel for the warden of San Quentin State Prison on January 20th and 23rd, 2012, regarding the petition and our grounds for seeking the conditions specified in the proposed writ, and we could not reach agreement on the terms of the writ. I declare under penalty of perjury, the foregoing is true and correct. All right, so what's that he's talking about? Bam, this is what he's talking about. These are the exhibits. This is just a standard 128G. So anytime you go to committee in the state of California, in the prison system, which you have a classification review every 6 months, but you also have one shortly after arriving to a new prison, or if something major happens. But otherwise, you go every 6 months. And this is classification, like I said. So 128G, you can see it in the upper right-hand corner. Inmate Villa appeared before the Pelican Bay State Prison Transitional Housing Unit, UCC, on this date for transfer review. The date of this document is June 18th, 2009. Prior to committee, the CCI, so it's a correctional counselor, was assigned as a staff assistant and was present during committee as subject is triple CMS level of care, right? That's Villa is triple CMS. So he's on some kind of hot meds, but he's not EOP, right? If that makes sense. So I don't know what. I don't want to speculate on what exactly the medication is. It might say, I haven't read every word of this yet, but Villa, what S is Villa, right? So has graduated the transitional housing unit program and has successfully completed the second phase of the debriefing process. This transfer consideration is based on institutional need for transitional housing unit bed space and shall not be construed as adverse in nature. So they're just doing this because they're trying to figure out who can we move out of the THU to make room for other people that have debriefed. Committee notes that the safety and security of Villa and the institution would benefit from his being considered for sensitive needs placement. His case was reviewed by IGI, the institutional gang investigator, with the CDCR 812 updated. 812 is your enemy list, if I remember correctly, to reflect changes noted in the CDCR 128B2, which is just a chrono release note. Please note the CDCR 128B2 dated March 1st, 2008, in the general section of the subject central file, which documents him as a validated dropout of the Mexican Mafia prison gang. Committee notes his successful completion of the THU education program. This program consisted of an intensive 14-week curriculum designed to include education, vocational training, personal growth, conflict resolution techniques, and physical education. Machine on track. Participation in all facets of the program was mandatory, as was double selling, exercise yard, day room, and group discussions. Ultimate goal of this program is to reintegrate these inmates into a general population setting. His performance on participation in the THU program, as well as the THU work program, was rated as average or above. He has been previously endorsed to SADF Level 4 SNY, that is Corcoran. However, due to a tracking error, the endorsement has expired. S and his assigned caseworker have had several conversations regarding his desire to transfer to Lancaster Level 4 270 design SNY. S wishes to transfer to that facility in order to be closer to his family and maintain these ties. If he cannot transfer to Lancaster level 4 270 SNY, he wishes to be endorsed to SADF level 4 SNY, which again is Corcoran. He meets the 180 design criteria due to the fact that he was housed in a SHU within the last 3 years. However, this was when he was undergoing the debriefing process. UCC determined that he should be given the opportunity to transfer to Lancaster 270. This is based on his willingness to debrief, his willingness to walk away from the prison gang mentality and politics, and his positive programming while housed in the THU. They also note that he has 2 confidential enemies housed at Lancaster level 4. However, according to the assistant CNPR at Lancaster, I don't know what the CNPR is, to be honest. Some role, some administrative role, I guess. These individuals are not housed on the SNY facility. Committee asks to refer via to the classification services representative with recommendation for special transfer consideration to Lancaster level 4 270 SNY with an alternate of SADF level 4 SNY. This recommendation to the CSR is a result of having specific level placements for gang dropouts, along with his level 4 placement score of 163. So you got a lot of points. This is a non-adverse transfer, and upon arrival at the new institution, his work group privilege group, that's WG/PG, work group privilege group will be A1A with closed day custody, effective 8/23/07. So you get more privileges if you have a job, right? If you're in A1A is the highest work group/privilege group. That's normally if you have a job or if you're participating in school. So because this is not adverse, because he's not in trouble and he's not being moved against his will, and he's kind of doing them a favor by freeing up bed space in a transitional housing unit, it's also doing him a favor because he gets to go out to a larger yard area. They'll go ahead and keep that. So he'll be able to go full dry canteen and all that stuff. Closed A is normal for lifers back then. It means like no night yard, and there's certain areas that you're not allowed to go to. Effective 8/23/07. The CDCR 127, CDCR 812, CDCR 812C, and 840 have been updated. He participated in committee and concurred with committee's opinion that he required placement on sensitive need yards at this time due to his validated dropout status. He stated, "Thank you, I really need to get to Lancaster to see my family," end quote. Based on the THU population pressures, he will be transferred upon CSR endorsement. Various penal codes complied with, and his appeal rights were explained. He was advised of the committee's decision and his right to appeal. He's been advised that any appeal of this committee action must be submitted within 15 working days of this date, whether he has received the 128G classification chrono or not. Next scheduled committee is June 2010 for annual review. This is the 128G chrono. Exhibit 2. Here's another chrono. This is dated September 5th, 2007. Same thing, 128G. This is the THU classification committee. And it says that it may appear before Pelican Bay State Prison, Level 4 Transitional Housing Unit Classification Committee on this date for his initial review of placement in the THU. Oh, okay, so this is when he first went to the THU, so 2007, which is around the same time that this lawsuit was filed, which means that he started the process of the appeals and institutional stuff while he was still active. Prior to committee, Correctional Officer D. Love was assigned as staff assistant and was present during committee as subject is triple CMS level of care. Committee effectively communicated with subject by using short sentences and simple English. S was received in the Pelican Bay State Prison Level 4 general population from the Pelican Bay State Prison SHU for completion of the second phase of the debriefing process and participation in the transitional housing unit. He is currently validated as an affiliate of the Mexican Mafia prison gang per the CDC 128B2 dated April 13th, 2005. So that's either when he got validated or that was his last committee prior to debriefing, right? Prior to dropping out, in which they reaffirmed his status. And again, see where it says he's validated as an affiliate of the Mexican Mafia. That's consistent with, I still stand by, I believe that he was a camarada, he was an associate, both in practice and in terms of his validation, not an actual made member, even though there is some of the legal work that does talk about him as if he was a member. But again, you got to take those declarations with a grain of salt. They're coming from civil rights attorneys. And this is 128 is saying that he's an affiliate, right? If otherwise they'd say he was a member. Completed first phase of debriefing process, and he'll be required to successfully complete an integrated yard program. Upon completion of the program, a validation package requesting dropout status must be submitted. Because when you're validated, at least how it used to be in this era, when you're validated, you're validated. If you're labeled as a member or you're labeled as an associate, that is what it is. If you drop out, you're then validated as a dropout, right? But you're still validated. They just change your validation, and you're now validated as a dropout associate of whatever or member or whatever. Back when they had the inactive reviews, right? 6 years inactive, which hardly anybody got. If you succeeded in that, no gang activity for 6 years. So they still validated you. They just changed what your validation was. You were validated as a non-active member or associate of such and such prison gang. That's where this active, non-active language got introduced to the masses. It was really about prison gang validations and a very kind of niche audience in the California Department of Corrections, and now has taken on a life of its own, right? With the different kind of yards and all that shit. Upon completion of the program, a validation package requesting dropout status must be submitted. After review of that validation package, a 128B2 gang validation chrono will be issued. Committee notes that as a validated gang affiliate who has only completed the first phase of the debriefing process, his housing and general population is in contradiction to the California Code of Regulations, Title 15, sections yada, yada, yada. However, the California Department of Corrections and Rehabilitation and Pelican Bay State Prison has traditionally exempted itself from these regulations, and he is endorsed for Pelican Bay State Prison Level 4 for THU placement by the Classification Services Representative, CSR, per the 128G, dated May 2nd, 2007. The THU program is an intensive curriculum designed to include education classes, personal growth, conflict resolution techniques, and physical education. You know, it's just template stuff. It's boilerplate, right? Participation in all facets of the program is mandatory, including double celling, exercise yard, day room, and group therapy sessions. The ultimate goal of this program is to reintegrate inmates that drop out of prison gangs into the general population facility with sensitive needs noted. Being a SHU inmate housed in the general population, he is advised of the THU program's zero tolerance policy towards any form of misconduct, and that any misconduct may result in his return to segregated housing. He has no known enemies in the THU. Committee acts to accept him into the THU, direct assigned to the THU program, and establish work group privilege group A1A effective August 23, 2007. Placed on the ACAD, the THU education program waiting list. He is approved for double celling. He is double celled with inmate White K66643 and states they are compatible. Established close A custody. Case factor. C-128G dated August 2nd, 2005. A concise orientation to the THU program has been provided, and subject will participate and sign that he fully understands the condition of his placement in the THU program. Penal codes 2930, 2933, 2934 complied with. He is not restricted from visiting with minors per CCR 3173. He is restricted from family visits per CCR 3177. That's because he's a lifer, I believe. He has participated and agreed with committee's actions, stating he did not foresee any future problems with his THU program. He is advised of the committee's decision and his right to appeal. He has been and is advised that any appeal of committee action must be submitted within 15 working days. We know the rest because we just read that. And then this is essentially another one, right? Which I really don't feel like, you guys need to read. This was, VIA was reviewed in absentia per his own request by the Pelican Bay State Prison THU UCC for annual and transfer review. There's nothing in here that is inconsistent with anything else. It does say, he's participated in all the programming. Subject has voluntary involvement with the Pelican Bay Reaching Out Convicts to Kids, also called the ROC program. Reaching Out Convicts to Kids. Okay. I never heard of that one. Committee acts to retain him in A1A status, closed day custody, and refer him to CSR with recommendation for special transfer to SAT F level 4 with an alternative Mill Creek State Prison level 4 SNY. So yeah, it's just more of the same, basically, right? There's nothing different. So this is Via's declaration. This is Dub's declaration. And you can tell by reading it and how similar it sounds, especially in this first paragraph with the other declaration that I read, that his attorneys wrote this up. What I would imagine is he probably had a phone call with his attorneys and explained to them, and then they typed it all up into this, right? If he had written it, it would look like this, right? Obviously. But yeah, so this is his declaration as communicated through his attorneys. I'm an inmate in the California Department of Corrections Rehabilitation, currently housed at Ironwood, CDC number J38001. I have personal knowledge of the following and can competently testify to the contents of this declaration if called as a witness, which is exactly what I think was said to start. Was it this one or this one? Hold on. Yeah, that's how this one starts out too, right? I have personal knowledge of the following and can competently testify to the contents of this declaration if called as a witness. And that's where we're at with this too. I'm a validated gang dropout with the SNY prison classification. As a validated gang dropout, I am targeted to be murdered by the MA and their associates because of my dropout status. The MA, so this is where this initially comes from. The MA is the most violent gang faction in California, credited with at least 300 murders per year outside prison on orders they were issued by the mafia from inside. I was granted SNY classification by CDCR because, in part, I went through a debriefing process where I incriminated myself and the MA. The MA could murder me at any time if I were not in the SNY program and I were not housed separately from the general population. This is common sense, right? It's like, this is stuff that you could say anybody that was a dropout housed in the California Department of Corrections would say basically the same thing. Nothing in this tells us exactly what Dub said during his debrief. So if that's what folks have been looking for, how far in are we on this video? Like, we're like 47 minutes in. If that's what folks were looking for, you're not going to see it, right? This is as close as it comes, where he says I went through and I incriminated myself in the Mexican mafia. During my transfer to Quentin for trial in October 2011, prison office placed me on CDCR buses with the general population. This also took place in June 2011 for the prior trial date. Even though the writ of habeas corpus ad testificandum stated that I should not be placed within the GP, prison officials disregarded this and still placed me with the GP. Even though there's a fence on a bus that separates validated gang dropouts who are SNY from the general population, this is not enough to protect me because the GP can see me when the guards call out my CDC number, name, and SNY classification. That notifies all Mexican Mafia associates of my presence. So this is the declaration that we already kind of heard the key points of in the first thing that I read, right? And so same thing, he just talks about, he comes off the bus, he gets put in a holding cage, there's 3 other people put in there. They ask if them dudes is active. They ask him if he's SNY. He says yes, nothing happens, but it could have. And then he gets to Chino, and he tells him that he's out to court. He gets brought down the way. Chino, from what I'd always heard, right, and I don't know this to be fact, but what I'd always heard is that Chino, in this time frame at least, I don't know how it is now, was a stronghold for the MA, right? That they they had a tight grip on that place. Obviously, it's a historically relevant institution, but that he gets brought down there and gets brought up to the area and it's like, hey, am I SNY? Am I supposed to be here? They're like, no, and get him out of there. Again, would you expect better from actives? Absolutely. Dubs wasn't active. So again, to wrap it all up, right? I feel like this is enough. This has been a long ass video. I didn't realize it was this long. I got to make the kids dinner, but He dropped out. He dropped out. He went through the dropout process of debriefing. He was housed accordingly. He had a lawsuit against CDCR. He had to be brought out to court to testify in his civil rights lawsuit against CDCR. In doing so, CDC tried to set him up and put him in situations, compromised situations, because he wasn't active. And they tried to get him around actives, knowing that he had a parole date coming up and a parole hearing, coming up. And if he would have gotten into an incident, that would fuck off his date. And so nothing happened in those situations, but the risk and this happening repeatedly led his lawyers and him to turn around and tell the court, this is what CDC's doing. Can you tell them not to do this? And from now on, just transport me either by myself or with other SNY people and stop putting me, exposing me to GP guys, because I'm not a GP guy anymore. And the court ultimately ruled yes, right? The court was like, yeah, for sure. No problem. And there you have it. There you have it. So that is my reaction. You asked for my 2 cents. I gave you more than a nickel, man. It's 50 minutes in. I'm going to let this go. But I appreciate you guys. It is what it is, right? And our journeys are our journeys. And I think if you hate the dude, this is not going to change your mind. And if you like his content, it probably isn't going to change your mind. But hopefully now I stop getting asked to go over something, because finally something was produced that actually has some substance to it and was maybe worth going over. Help others move in excellence. That's what homies do. Help yourself at the same time because you're worth it. Help your community because they need you. Make sure you got the bell notification hit. I appreciate it if you would like this video, and stay tuned. There's more content coming.